Starting a topic today that I believe is in great demand these days. I'm talking about students. Students who come to the UK can, for whatever reason, not complete their courses, cannot continue with their courses, or want to switch for whatever reason. This video today will discuss a number of those options, number of problems that come with that, and what you can do in those situations. So let's get straight into it. First of all, the situation I want to discuss is that where a student has been withdrawn from the course. Now, this could be either because of non-payment of fees, or it could be because the student could not carry on with the course. Now, or they simply stopped attending course, and the college has informed them, or the university has informed them, that now we are going to withdraw you from the course due to your attendance or your lack of improvement in the course, or simply for non-payment of fees. What that means is that the Home Office will be informed by the university or your sponsor that you are no longer carrying on with the course, and the Home Office now needs to curtail your visa. The Home Office will then write to you and give you 60 days time in order to either leave the country or switch to a different category. Now, the first question people ask is, how long will it take for the Home Office to get back to you? And there is no right answer for that. I've seen that kind of letter come in within 4 to 6 weeks, 4 to 8 weeks, within 2 months, or I've also seen sometimes a year and a half pass, and still there is no letter from the Home Office. So you cannot rely on that alone. If that is your situation where you could not carry on with your course, my advice to you would be immediately switch to a different category or put in a different application, because if you're simply sitting there waiting for the Home Office to write to you, and the Home Office does not write to you for a year, after that, if you want to switch to a different category and you make that application, you could then be refused on the grounds that your course was withdrawn or your sponsorship was withdrawn over a year ago, and you still carried on living in the UK and did not make any contact with the Home Office. So the best thing to do would be, if you've been withdrawn from your course, you know what you want to do, immediately contact the Home Office if the Home Office have not automatically got back to you, and ask them to curtail your leave and to give you that 60-day notice, so that you can work with a deadline and know what you're going towards. So this is the situation where you've been withdrawn from the course, could not carry on for whatever reason. My advice is always switch to a different category or make another application rather than simply sitting on that visa. Because if you don't do anything, you could be sitting on that visa. For example, I had a consultation, I think it was yesterday. The guy said that he came to the UK in 2023, July 23, something like that. And he said that I've still got a visa till December 2025. Now, that means that even though he's been withdrawn from the course, if the Home Office does not write to him, he does have a document or a BRP that says that his visa is still valid till December 2025. Now, if he doesn't do anything, the Home Office does not write to him, he's not illegal in the country. But if the Home Office were to question that, then there would be a problem, because then he will not have any answer to why he's just been sitting on it and not doing anything. So the better thing to do would be, once he has been withdrawn from the course, he knows now that his visa could be curtailed at any time and that he's not entitled to that student visa anymore, then he should look for an option. Once he finds that option, immediately contact the Home Office, let them know that he is still waiting for the decision or for the curtailment from the Home Office, and either make an application or ask them or invite the Home Office to curtail the leave. In short, you need to take some action. That's the first thing. Now, the other point that comes in, what are the options? What can you do? Now, the kind of situations I face with students in these situations is, once they've been withdrawn from the course, let's say they've been given 60 days. Now, either go back to your country and make sure that your visa is safe. Your current status means that you're not an overstayer in the UK if you've been given that 60 days time. So if you leave at the end of the 59th day and you've not overstayed in the UK, in theory, you can go back to your country, apply for a visit visa again, apply for a skilled worker visa again, apply for a student visa again. You do not have a bad immigration history. You could not continue with your course for non-payment of fees or for attendance problems or health issues or because you couldn't complete the academic side of things, but that doesn't mean that you became an overstayer. So you can still maintain a good immigration history if you go within that time. Now comes the situation where 90 or more percent of people come and say to me, well, I'm not going back. I spent so much money to come to the UK. I cannot just go back. I've borrowed money. I need to have completed my course or started doing something with my life, and I'm not able to do that. In those situations, what are the options? You can see whether you go towards a human rights application, which is simply going to be what? That I have significant difficulties in going back. That's the only thing you will face. That's the only application you can make. Now, this application, you can say, is within the immigration rules, in the sense that we are arguing that you've not spent 20 years in the UK, you don't have a child with you who spent more than 7 years and is still under 18, or you've not spent more than half your life in the UK and you're still between the ages of 18 and 25. Now, if those three things do not apply, then the fourth thing we can argue is that you will have significant difficulties in settling back in your country. And that is a point that we can take to argue human rights elements in this matter. The other thing, if somebody says, well, I've got married now, I've got married to a British national, or I've got married to a skilled worker. Now, this is a lot of clients these days, where this is the sort of situation where they are getting married to people who are coming here on skilled worker visas, or they might have their partners back home. A lot of Indian clients come and tell me that my fiance or my wife has come over now to the UK and now she's on a skilled worker visa. I've become an overstayer, or I'm a student, I could not complete my course. Can I be a dependent on her visa? Now, if you've not become an overstayer and you still have a valid visa, you can possibly switch on to that category. But if you are an overstayer, please understand, as an overstayer, you cannot switch as a dependent. As an overstayer, if you want to be a dependent on a skilled worker visa, then you need to leave the country, leave the UK, spend at least 12 months outside the country because you've left voluntarily, and then you will be eligible to make an application to come back into the country. Again, it's a very simple thing to understand, but it's a technical thing. Once you understand that, then you will not go wrong with it, and you will not fall foul of those lawyers who just do not care and just tell you, yes, everything is possible, everything is guaranteed, everything is 100%. When somebody talks to me about percentage, and by the way, let me take this opportunity to say, if you're coming to me, please don't ask for guarantees. Please don't ask for 100% or don't ask for percentage chances. Nobody in the world can calculate those chances. Nobody in the world can tell you that. The only thing we can do is we can look at the law with our expertise, with our experience, with our knowledge. We can then advise you, in our opinion, what can be done. The decision maker is at the Home Office or in court. Those decision makers will then look at what we present them, what your evidence is, what your credibility is like, and then they will make decisions on your applications or on your appeals. So there is never a guarantee of a decision because we are simply not the decision makers. Next point. I'm looking at those people now who want to stay here. I've spoken about those who have been withdrawn from their courses and they want to switch on to another category. Now, if they have legal status, they can switch to another category. Now, if you're looking at those people who came as students and could not complete their courses, and then they want to become dependents on the skilled worker visas, they cannot do so. They're not allowed to do so, because this is the ruling that, or not the ruling, the rule that came out last year in July, where the Home Office announced that any student who could not complete his course will not be able to switch. And that includes switching to other skilled worker categories or to skilled worker dependents. The other thing I hear a lot is, okay, I became an overstayer, then I went and claimed asylum. Now I've got immigration bail. It's been over a year since I've been living in the UK after my asylum claim. And that means that now I'm allowed to work. Because I'm allowed to work, my lawyer told me that if you can get a skilled worker sponsorship, then you'll be able to get your visa. I don't agree. I don't think so. Because if you look at the rules are very clear. If you're an overstayer, you cannot switch. If you have immigration bail, you cannot switch. The other trick people are doing and poor clients are falling into is those EEA applications now. What is happening with that? EEA applications are now closed. Those relations are finished. Those categories are finished. what we are now witnessing is that people are still offering that, okay, you come to us and we will do an EEA application, we'll invent a relative for you, we'll submit an application for you, you will get a certificate of application which will say that you're allowed to stay here for 6 months, you're allowed to open a bank account, you're allowed to get your national insurance number, and you're allowed to work for 6 months. What happens after that? Then your application is refused, and then they promise you that we'll switch you over to a skilled worker visa because you've been given a certificate of application. Certificate of application does not confer any immigration rights on you or any immigration status on you. So if you do not have immigration status, again, the same problem arises that you cannot switch to a different category. So again, I think this is a scam. A lot of people right now are falling foul of this. I've spoken about this before. Please stop giving your money away. I heard from a client today that she spent £21,000 to get her daughter over on a skilled worker visa. And once she's here, the employer obviously said, there is no job, there is nothing like that, and you can go and make a human rights application. So if you were just going to do that, what's the point of spending £21,000? I don't know how people get that kind of money to spend on these agents and on these illegal activities, but please try to stay away from that. It's not doing you any favors. It's only harming your chances of immigration to UK or anywhere else in the world, because once you have been identified as a fraudulent entrant into the UK, then you will always have that stigma attached to your name and to your immigration history. The only other thing I wanted to speak of is generally looking at the students, generally looking at their problems. The best thing to do, if you are being offered a skilled worker visa, you haven't completed your course, or you are getting married to somebody, you haven't completed your course, instead of trying to push it from here, go back to your country and apply for entry clearance. Because if you're not an overstayer, it is easy for you to go back and apply from it. There is nothing stopping you from that. I really hope this helps, and I really hope it sheds some light onto those students who are constantly going from door to door trying to get some advice and constantly being given conflicting advice. I hope this helps. Speak soon. Thank you.